All right, this is the PowerPoint for Chapter 2 on the Constitution and constitutional law. There is a separate PowerPoint for the Bill of Rights, the first 10 amendments of the Constitution, and we'll get to a point in this particular lecture where it will break off from that. We'll have to look at a separate PowerPoint, as I said, for that entire section on the Bill of Rights. So here, I'll just put all this up here, the main aspects, things I think you need to focus on, and there's actually one more I probably should have added on this, but the key thing to think of here for the U.S. Constitution and constitutional law, the Constitution itself is what I would say is definitely a living, breathing document. There's a lot of things like the Electoral College and how the president is elected not by a popular vote, but essentially an electoral vote.
And it's complicated, not too complicated. It's something that a lot of people say is outdated. It shouldn't necessarily be that way. The fact of the matter is, every day there are constitutional law cases that are heard in federal court, and even state court issues or constitutional law issues come up. So, in particular, when we're talking about our Bill of Rights, our freedoms that are in frequent, frequent debate, truly, of the meaning of the terminology, and we go with that, and in terms of our expression rights, it's expression in the way of things like burning a flag. So, Constitution is continued to be a couple hundred years old plus. It's constantly a matter of legal discussion, debate in courtrooms across the country presently. Also, the Constitution, the primary source for the structure of how our government is set up and how the branches interact. And excuse me, when the president is making decisions as to often there's got to be a consideration as to what the different constitutional power of the president to do certain things. Likewise, Congress. The Supreme Court will be looking at the same to make a determination of constitutionality. So, the shape of government and the interaction between the branches is, in terms of the powers and checks and balances are significant. I'll give you a bullet way to memorize them. It may work for you, it might not. But hopefully it does help. And included or not, that almost led to us not having a constitution until the framers of the Constitution actually set the 12 aside, and we'll debate them later, and later on dealt with the Bill of Rights. So it was a separate document. The Bill of Rights essentially is aimed at limiting the power of it. So when we go through the Bill of Rights, you'll see that the key word is power, and again, the Constitution, a key word for the whole entire Constitution. The premise of constitutional law is power, and not having power be too located in too narrow of an area. And so we'll get to that and talk about it. We talked about in Chapter 1, but we'll touch on that again too, and judicial review and police power, we'll touch on that as we go through. So these are the main objectives I would add one here, and that is understanding how the constitutional amendment process takes place. And it's significant because there have been so few amendments to the Constitution in the more than 200 years that it's been around. And so that is directly related to the fact that the constitutional amendment process is so difficult. The framers of the Constitution didn't want the document that they created to be so quick current political situation, so they made the process a very challenging one. So you'll see that, and we'll go through that as well here too.
So here's some basic concepts, and I apologize for all the words on this slide, but the basic idea here underlying our system is a system that's a federalist system. There's a lot of debate about this in the beginning of the Constitution when it was being drafted as to how much power states should maintain and how much power a central government should have. And a strong federal government is a national government is what was decided ultimately. The smaller states, the less populated, less powerful states were concerned about being consumed by a strong central government and having less power to do what they wanted within their own territory, and that's still an issue to this day. Federalism is a system of shared power between the states and the federal government. Other countries that have this kind of system, for example, are Germany and Switzerland. There are other countries around the world that have a federalist type of system of federalism, and that's the basic gist of what it is. So in order for each of the states to be part of the union that is the United States of America, they basically had to delegate powers, hand over powers to this national government. And so one term that you need to know or understand is delegated powers. And so when the states accepted or ratified the Constitution in each of their respective legislative bodies, they basically accepted the fact that the central government would delegate or give up powers to this central government. And it says here, mentions enumerated powers. Enumerated powers are those powers specifically expressed in the Constitution that are granted to the federal government. Powers like being able to raise an army and a navy, being able to coin money, those types of things were left to the federal government and not state governments. So being part of the United States meant that each state, in ratifying or accepting the Constitution, that they delegated powers over to the national government. They also reserved powers, so things that weren't specifically enumerated or spelled out in the Constitution for the federal government to be able to do, those that meant that there was reserved powers, and it may not have been expressed specifically what those powers were, but written out.
Anything that says power that the states reserved, and would be able to argue
later on that they still maintain powers that the national government doesn't have if it wasn't spelled out in the Constitution. Another aspect of the Constitution that's significant here is this idea of separation of power. And separation of power, this is like any middle school or high school civics class you'd recognize. I'm sure that there's these three branches of government, each with their distinctive duties. The executive branch is supposed to enforce the law that's created by the legislature, and the judiciary essentially interprets or clarifies what it believes the law is that's spelled out by the legislature. Each of those branches have distinct duties,
and they have checks and balances against one another, so that
no one branch technically has too much power. One significant thing that it separates us, I think, across the world, and some countries really can't understand how we do this, and people assume the highest executive in the United States, because the United States has signed this treaty,
that it's law. And it isn't. Just because the president signs this treaty in another country, or an agreement like that with another country, the Senate, the U.S. Senate, basically has to ratify or approve it. And that goes back to the idea of our former system with the English king, and the king being able to dictate to people, the colonists, what types of treaties that and things that must be followed. And so in this sense, the Senate is again, there are many examples, but that is one example of how that process works. Okay, the next step here is the Supremacy Clause, and the Supremacy Clause is basically it's set forth in Article 6, Section 2 of the Constitution, and it spells out the fact that the Constitution and federal law treaties are the supreme law of the land. And so what that basically means, whenever there's a conflict between state law and federal law, the states will lose. So even though several states on the West Coast here, we've got California, Oregon, and Washington legalizing marijuana for medicinal reasons, it is still a violation of federal law. And while it isn't always enforced, certainly in large cases where people are distributing large amounts of marijuana, people will get arrested, and even if the claim is that it's for medicinal reasons, it won't matter. The supreme law of the land is the Constitution. Again, when states signed on and ratified the U.S. Constitution, they agreed to this. The U.S. Constitution, treaties, federal law that's drafted by Congress, those are all supreme and must be abided by the states. Okay. Right, Commerce Clause. Again, this is Article 1, Section 8 of the Constitution, and the Commerce Clause specifically dealt with it. It says federal authority to regulate commerce with foreign nations among the states and Indian tribes. And it's spelled out that way. The Indian tribes in the day of the Constitution were considered to be separate nations, and so the focus of Congress's federal authority, the focus is on interstate commerce. So that's any commerce or trade that happens between states. And I have just kind of highlighted the E as one way of memorizing. Interstate is between states. Intrastate is trade within a state. So any commerce, our federal government has an ability to regulate that. Government would not be able to do that. They might try, but there could be a trade between say Washington State and China or Japan or somewhere else. Again, that's interstate. It's within, from one state to another area to a nation, and in that sense, it could be regulated by our federal government.
Right. This next slide just points out where we would need to go here, and I'm going to have a separate presentation for you on the Bill of Rights. That would be the next step of where we would cover. And then now, for this point, I'm going to step in and be a little more specific, dealing with one of the amendments, actually several of the amendments in a row here, but specifically a little more focused on the First Amendment, and then we'll move forward from there and give you some background on the 14th Amendment too, on equal protection, just as more detail from what I provide for your memorization methods for the Bill of Rights. I'm going to go into more detail now, starting on the First Amendment. So, freedom of speech, it is, I'll back up. All of the amendments in the Bill of Rights, the first 10 amendments essentially, are not without limit. They all have some limits, even though people will say, I'm free to speak, I have free speech, I have a right to speech, and those types of things. There are limits on all the first 10 amendments. Free speech, and that's in the First Amendment, can be, as it points out here on the slide, it's oral, written, and symbolic, so it could be something you write, in which you normally don't think of as typically speech, or a symbol, an expression. It can be a form of speech too. It's been interpreted that way. And what is the most protected level of speech is political speech or political expression. This was during the Vietnam War, and students in high schools and college wore peace armbands and were expelled from schools, and it was claimed, ultimately it went to be a U.S. Supreme Court case, and it was claimed to be a political statement. Political speech, even if we don't like it, is the most protected level of speech or expression that we have. I grew up in the Chicago area. There's a suburb of Chicago called Morton Grove, and Morton Grove is a predominantly Jewish town, and the American Nazi Party wanted to march through Morton Grove, and the local city council passed a couple ordinances and made it very challenging, more or less prohibiting the Nazi Party from marching. You had people who lived there who had survived the Holocaust. They had the numbers on their arm from the concentration camps that they had been in. And it was something that they absolutely thought was inappropriate. And when this case went through the courts, I believe it was the Supreme Court, it might have been an appellate court in the district there in the Midwest or in Illinois, but I believe it was the U.S. Supreme Court. They ruled and they said that it is free speech, and we might not like it, but that's a flag. And while that offends an awful lot of people, people who have died or family members who have died, it's
been a big issue. Whether someone burns a flag should be allowed to do that. That too has been considered to be political speech, and it's fully protected under the Constitution to do that. The next level in this area of speech is a little bit more limited, and this is an area of commercial speech. And in this case, wanted to do some advertising, and they had big billboards that were up in the city of Baltimore had some strong concerns about teen alcohol abuse and teen drinking. Of Baltimore passed an ordinance that basically prohibited the sale of parks and schools and playgrounds, and that's prohibited entirely from advertising. They certainly could, on the interstate next to the near the baseball stadium or football stadium was totally appropriate, they felt, but they just didn't want to have lost, even though they claimed it was their First Amendment right. Basically said this is appropriate to have a time or place or manner restriction, and there's limited speech that can be protected. Anheuser-Busch in a different case. Anheuser-Busch won because there were so many schools in Boston that basically what it meant was, for all real intents and purposes, Anheuser-Busch would so. In that case, they won because it wasn't considered to be entirely took away First Amendment rights of Budweiser, Anheuser-Busch Company won. But in this case for Baltimore, because there was other access for the company to go and do this, was considered to be totally appropriate restriction on the speech of the company. All right. Now moving to, so we started with most protected speech now, and then limited protected speech, and now we get to the speech that when somebody says, well, it's my First Amendment right to say this thing, they're wrong because it's not protected by the courts. And I think very early in the quarter here we talked about somebody yelling fire in a crowded theater. Dangerous speech, if it's not true, there's not really fire. This is a rock concert or something, and there's actually fire there. But if somebody yells fire and there isn't a fire, they can't later on say when people are hurt, well, it was my First Amendment right to say this. Fighting words. You see people now will say things and they incite a riot or they incite a fight because they've started this thing. They can't claim again that was their First Amendment right. They certainly can claim it, but they're not likely to win because it's not going to be protected. Advocating violent overthrow of the government will not be protected. We certainly have a First Amendment right to walk down the street and march with flags and banners and that type of thing, but advocating violent overthrow of the government will not be okay. In some cases you've seen where someone has a website up and they make a claim, they tell people how to make a bomb, or they say this is how you should overthrow the government. That will not be protected, and they can't claim it's protected. Certainly not win when they make that claim. And then these things make common sense. Defamatory language, if you say something false about someone and post it on a website or put it in a newspaper or do something with it, you publish it in some manner, that's not going to be protected. Child pornography and what is considered obscene speech will not be protected either. Obscenity is kind of a peculiar one, though. The U.S. Supreme Court recognized that in different areas of the country, different towns, even counties, different areas, different perception of what they consider to be obscene, and other places might not say that. So, for example, if you walk in downtown Seattle, you certainly could find a stranger, the newspaper, The Stranger, and while some people might be upset about it, it's not considered to be obscene. Take that same newspaper and put it in, East Texas, or saying that some material in it is the definition of obscenity up to local community standards to make that decision, and has not dictated by law, court decisions exactly defining what obscene speech is, but it's basically saying it's not protected depending on the community standards that are present. Okay, so the First Amendment deals with freedom of speech and freedom of expression. That's one half of it. The other part of the First Amendment deals with religion. And there are two aspects of religion that are addressed. One deals with the Establishment Clause, which basically says that government isn't supposed to establish or promote a religion in any way. It's interesting that this is the, how do I say, often you'll hear the statement of separation of church and state, and the idea is that in our country that government isn't supposed to promote religion, any one religion, and a lot of that, it's interesting, this is in the First Amendment, a lot of the framers of the Constitution were people who themselves or family members or acquaintances, friends, had escaped persecution from the king in England for religious reasons, and that's why they moved to the colonies in America. And so the freedom of religion and freedom of keeping government from promoting any one religion was basically the idea was no one religion, or if you chose not to exercise any religion, that would be your choice. So
The one half of the First Amendment on religion deals with establishing or promoting religion. The other half of it deals with the free exercise portion of it, which means you and I should be able to exercise or not exercise religion as we see fit. So the two components of this can be challenging in some challenging cases. An example of the first half of this Establishment Clause in Seattle at SeaTac Airport a few years back, around the Christmas holidays, there were some Christmas trees. They weren't decorated. I don't believe there wasn't any presents or anything, and there wasn't any nativity scene like the baby Jesus looked like Christmas trees. And someone threatened a lawsuit against the Port of Seattle, because the Port of Seattle being
a government entity. They were saying they were promoting the port, rather than fight the lawsuit, just took the trees down. Now, that might seem silly, but there's this idea again of not establishing or promoting religion. I lived in California with a gigantic nativity scene, the baby Jesus and the wise men and all that, out on the lawn of the city hall. And they were sued at promoting one religion and the Christian religion, and there should be other religions out there as well, Judaism and Islam, or Kwanzaa. There should be all sorts of things up there, or you promote no religion whatsoever. So the lawsuit happened. I can't remember, but they had to take the nativity. We'd be allowed to exercise religion as fit. There again are limits to this. There was an alleged religion in Los Angeles a number of years ago, where the women who were members of the congregation were required to, in order to raise money to help with other social causes in the community, the women who were members of this quotes church were out prostituting themselves on the streets of Los Angeles. And of course, when they were arrested for prostitution, they claimed it was their First Amendment right under their religion to be able to do this. And when it came down to it, no, your free exercise right of religion, of free exercise, was the case. I believe it was in Louisiana or Mississippi, and it involved a church that was sacrilegious rituals, and an rights group had sued the church to stop because they wanted this to be done humanely, and they said it was a violation of all sorts of laws and that type of thing. And the church, of course, said this is our First Amendment right, and we have a free exercise right of the humane treatment of animals for slaughter, is how it was interpreted according to the particular law in that state. And so, again, there's First Amendment rights, and there's going to be limits, and those are a couple examples of some limits here on the religion rights side of things. All right, moving forward into equal protection now. And I mentioned, I think earlier in the quarter two, we've talked about equality quite a bit. And this is a significant issue when we're looking at how the Supreme Court interprets equality. And if you read the 14th Amendment, here's the language right from it: no state shall deny to any person within its jurisdiction the equal protection of the laws. So, first of all, this applies to states, is what some folks have argued. The Fifth Amendment portion of this is the flip side, and some people say that dealt with the federal government and equality, but the 14th Amendment dealt with states and equality. And some history here. The 14th, 15th, and 16th Amendments were passed almost right together, right after the Civil War. And the Civil War
resulted in the abolition of or ending of slavery. And so the 14th and 15th and 16th Amendments were anticipated to mean equality for African Americans in our society. And so treating people equally was the intention of this. So how it has played out over the years, how the Supreme Court has ultimately looked at the 14th Amendment, is it's said that we are all equal, but there are three levels of equality, and where we focus our attention on this primarily is what's called strict scrutiny. If there's a state law that impacts someone on the basis of their race or national origin, then it says it applies to suspect classes. So depending on if this law applies to someone on the basis of their race or national origin, and it discriminates against people, say, who are Hispanic or African American, or name a group, then the court is supposed to follow a pattern of strict scrutiny. Those groups, racial groups or national origin groups, are considered suspect classes, and automatically how the court is supposed to interpret this is on the basis of strict scrutiny, which basically means that the state has to have a compelling interest for why it treats someone unequally. Why is it discriminating? It has to have some compelling overriding interest in doing this, and so that's one type of standard. And again, race and national origin are primary because that is our history of discrimination, particularly coming out of an era of slavery and the civil rights movement as we move forward from the 1960s on, and that's why the cases focus primarily and say strict scrutiny should happen in those cases. If your case did not involve race or national origin, and say it involved gender or age discrimination by a state in legislation that was passed, or that these are protected classes, but the level of scrutiny or analyzing how the court will go about this is less strict or less stringent. And so basically, this intermediate scrutiny says if there's discrimination against, say, women that's by a statute that's passed by a state, then the state has to have some substantial relationship between and that's the language that's used, substantial relationship between this discrimination and the governmental interest. What is the interest of the government in doing this discrimination? There has to be a substantial relationship between those two, so that makes sense. And in that case, if there isn't that substantial relationship, then of course the law will be considered to be a violation of the 14th Amendment, just as under strict scrutiny, if there wasn't a compelling overriding state interest or reason for having this discriminatory law, then the 14th Amendment would override the state law and say that it was discriminatory. And so strict scrutiny for race and national origin, if you're not in that group or suspect class, then if gender and age is an example for other protected classes. If you didn't fall into either of those two groups, the U.S. Supreme Court has looked at what it calls a rational basis test. And so basically anything else, any other type of group, what the government interest is, a government claims that it has a right to discriminate against people, is there a rational
basis for doing this? States have argued that the only way that marriage has ever been has been because it's been between a man and a woman. So our rational reason is following precedent and following the way of the U.S. Supreme Court. It's very likely that the U.S. Supreme Court's test, that's totally appropriate, because again, gays and lesbians won't fit in the discriminatory levels that you're looking at for intermediate scrutiny or strict scrutiny. So rational basis would likely be the test in that case. So again, that's why there's the attention focus there when we're looking at equality and how that takes place. So the next one here I'll just cover, and then this will be the end of part one of this PowerPoint for the constitutional law. Is another aspect of the 14th Amendment, which is called the Privileges and Immunities Clause, and basically this is stating that no state should be allowed to have laws that discriminate against citizens of other states. And so basically it prohibits states from enacting any type of a law that does discriminate in favor of their own state citizens versus citizens of another state. This gets kind of tricky here over residents of other states. I've just finished that piece there. This gets tricky because in some cases you may be very well aware if you want to go to transfer to a university that's in another state, you're going to very likely pay a lot higher tuition than someone who lives in that state. And again, this would be from a plain reading of the 14th Amendment here, the Privileges and Immunities Clause. You would say, well, okay, I'm a Washington citizen, and if I go to Oregon and want to go to school, why should I pay 3 times of what an Oregon student would pay, Oregon citizen student would pay? And you'd say that's a violation of the 14th Amendment because you're discriminating against me. One way states have gotten around that is because, it's particularly for state schools, they will say that property taxes and other taxes that local citizens pay is going into that, and so they've already essentially paid a surcharge, and so they say that somebody from out of state hasn't paid that, and so that's why they can justify a discriminatory type of behavior here. I'll give you a different example where it wasn't okay to do this. I grew up in Illinois, and in Illinois the drinking age was 21, and in Wisconsin, just over the border, very close, not too far from Chicago, the state law was, I believe, 18 or 19 to be able to drink alcohol. So where did people go? Young kids go as they drove in their cars up to Wisconsin, and they would get drunk, and then they would drive back, of course, drunk, and be getting arrested by police. Wisconsin police were not too happy to have this happening, even though the law was very clear as to being of legal age to drink when you're younger. They weren't happy to have these younger drunk kids going back and forth, and so they were giving us stiffer penalties to Illinois residents. Well, that's not okay under the 14th Amendment if the same exact crime is being committed by someone in Wisconsin who's a Wisconsin resident, and then having the police or government treat residents of Illinois with a different level of penalty. So that would be a violation of the 14th Amendment. And there's an example for you of that. And with that, we'll end part 1 of the chapter on the Constitution and move on to part 2. We'll end this for now. Okay. Thank you.